This is a live stream. My name is Emily Ann Page, and we are currently going live on Facebook, LinkedIn, and YouTube. So if you're watching us, I'm glad to have you here. We are going to talk about some important topics, and I have an expert. Oh, wait. I already promised him I would not call him an expert. He's actually an attorney at law, and he is also a friend, and his name is Aron Phillips. And so, Aron, thank you for being here today.
Yeah, thank you. And yeah, so we're not allowed to say expert in relation to our practice area unless, for Texas at least, if we're board certified in that area of law. And so at this point, I'm not board certified in a particular area, but some areas, for example, are personal injury, litigation, that sort of thing.
Okay, so that's good to keep in mind. So your attorney cannot be called an expert unless he's certified in that area, and some certifications don't even exist. So, but we have Aron Phillips here today because we are going to talk about an important topic that is relevant to you if you own a business or advise anyone who is running a business. The topic of today's webinar is 6 essential contracts for brand owners. So this is basically a small business legal advice 101. And we're going to go over 3 areas that you need to have contracts in place. And we're going to answer this question: what are those contracts? And when can you do a quick thing like LegalZoom? And when is it actually important to hire an attorney? I know everyone watching is interested in bootstrapping and saving money. And all of us are really, that's an important, essential quality to surviving as a small business. But at the same time, one of our biggest risks when we run a small business is getting sued or losing clients, or there's all these different concerns that we have that are risks, and those risks we want to prevent. And so that's why legal contracts exist, to be able to improve and clarify the relationships that we have when we do business so that we are protected if anything ever goes wrong. So I want to also explain really quick Aron Phillips, who is here. He's an attorney at law licensed to practice in the state of Texas. So if you want an attorney and you want to follow up with him, feel free to reach out to him if you are in Texas. If you're not, you can also reach out to him if you have advice about how to search for and find your own attorney in your own state, because some of this stuff is state specific. But Aron is an expert in contracts, mergers and acquisitions, and he's going to talk to us about general things. So no matter where you're at, you are going to be able to learn something. So Aron, would you start by telling us what are 3 categories of relationships that we should probably have contracts in place for?
Yeah, definitely. So the first is internal. So within the business itself, you want to have employment agreements, independent contractor agreements, that sort of thing. And then looking upstream, at vendors, factories if you're manufacturing something, and then also looking downstream at, who are your clients, your customers, your retailers, people that you're sending your product onto or delivering services to. So those are kind of the 3 basic categories and how to think about them.
So for everyone watching, so we are talking about contracts in those 3 categories: employees and contractors, vendors and factories, clients and retailers. So we're going to actually step into each of those categories one by one. And Aron is going to talk about what contracts should you consider having in place to protect yourself in each of those areas. So Aron, would you mind telling us about employees and contractors? What types of contracts should we have in place?
Yeah, sure. So internally, the employment agreements or independent contractor agreements are 2 different kinds of agreements, and that's really for 2 different kinds of relationships that you're going to want to have in place with certain people. You don't need them in place. So let's talk about first, when does the need, when do you hit that threshold? If you just have, for example, a receptionist or an assistant, and the only real thing you have with them is an hourly wage, maybe some fringe benefits, then you probably don't need some sort of agreement in place. But if they're the kind of person who's going to be intimately connected with your business or learn all kinds of details that you don't want getting out to the public, you may want with them, instead of an employment or independent contractor agreement, you may want some confidentiality agreement in place just so they understand they shouldn't be sharing this information with the public. So for example, my assistant, even though I don't have an employment agreement with them, I have them sign an NDA, a non-disclosure agreement, so that they understand all the information that they're getting exposed to, client information, details about the firm. They can't share that with the wide world. So that's kind of a base level agreement, maybe even pre getting an employment or independent contractor agreement for some of those first few employees. Once you grow to a certain size, maybe 5, 10 employees, it depends from business to business. You're eventually going to get people who you may want to make sure are locked down in various ways post-employment or post-relationship. So what I mean by that is somebody that you don't want to be contacting your customers, somebody that you don't want to be stealing your other employees and setting up shop across the street. So having non-competition and non-solicitation provisions are the kinds of things that you want to put into those agreements. And it's important to know what kind of person you're dealing with, whether they're independent contractor or employee, at least in Texas, because independent contractors can't be subject to a non-competition agreement. Employees can. However, you can still, for independent contractors, have non-circumvention agreements, non-solicitation provisions, and things like that can still protect your business, but it's not quite as broad of protection as a non-competition agreement.
Okay, so for everyone joining us today, we're talking about contract essentials for small business. And right now, what Aron is sharing with us are contracts that you should put in place that protect you in one of 3 categories of relationships that you will have, and that's with your contractors and your employees. And so as for Aron, thank you for explaining to us that we would want to consider having that there's different types of categories. So the more intimate the relationship is with the employee, the more you might want to have a more strict contract. And so can you explain to us, what is the risk? So you talked about if it's a receptionist, perhaps she doesn't have access to really intense information, but there's a different type of employee, one that maybe is a sales rep, a CEO, a vice president.
Yeah.
What are the risks that you're facing? What are we protecting ourselves from when we put in place a non-circumvent and a non-compete, these contracts that you're recommending?
Yeah, so the risk you run if you don't do that is that after they leave your employ, they can end up setting up shop across the street. So, you can't tell people not to have relationships with the people that they have relationships with, but if they were introduced to those people through you, so if you built out this great prospect funnel, this great sales funnel, and built this great network and then introduced them to that network, and so the only reason that this person that became your top salesperson became that and did that within your industry or within your area was because of you, you'd want to protect that. So that way they don't just go either to a competitor across the street or across town or set up their own shop. And so that's the purpose of the non-compete, because once they leave, if they are the main person, they're the face of the company for some of those for some of those customers, then those customers may leave to go with them. And so you want to make sure that there's some protections in place. And we'll talk about this a little bit later, but then you would also tie that in with any agreements that you have with those customers, perhaps to say they can't leave with one of your employees if your employee leaves.
Right. So that's helpful. So anyone who's watching, what we're talking about then is protecting ourselves from risk. So it might feel frustrating or annoying to put in place a contract and to have to think through creating templates like this. I know for myself, I'm a busy entrepreneur. I don't really have time, and I try to focus on the most important thing because there's a million things I could be doing. But What Aron is explaining is that there's risk in the future for when a contract goes sideways. And if I do consulting for small businesses to help them grow, and I can't tell you the number of successful companies. It's when they're unsuccessful or when they're like brand new, they don't put in place these contracts because they don't think they need it. They can't imagine a world where they'd be so successful that anyone else could hurt or care about their company and their revenue or their processes. But it's once they become successful that it's hard you can't go back retroactively and put those contracts in place. And so your number one sales, he can leave and go work for your competitor. And suddenly he has all of your pricing, all of your contact information. And that did happen to a client of mine. And daily they are having to deal with that person try to outbid them and compete with them in the same exact identical space. And so we're talking about avoiding risk. That's the point of a contract. And so we're talking about, again, employees and contractors. So Aron, can you explain to me based on that, what is the action item? Like when should we go to like LegalZoom and it's okay to use more generic templates and NDA? And when is it important to actually hire an attorney? And what would that kind of look like in terms of time, cost? Can we use that template again as an investment?
So I'd say once it rises to the level of needing some sort of non-competition or non-solicitation provisions. Once it rises to the level of needing those, at that point, I'd say don't go to LegalZoom. Don't try to bootstrap it, because different states have different requirements, and different states have different laws, and also different industries might look different. And it's important to understand what are the courts actually enforcing. Because, to give an example, in Texas, if you write something that's overbroad, then during the period of time that they're violating it, they're not going to be punished for it because you had an overly broad restriction on them. And so making sure you get legal counsel if it rises to the point where you feel like you have something worth protecting and want to put those provisions into a contract is important. I think, perhaps for basic confidentiality agreements, if that's all you're doing is just a basic confidentiality agreement, that could be something you get on LegalZoom. But if we're talking about employment agreements and independent contractor agreements and putting additional restrictions in there, then you should get an attorney. In terms of cost and outlay, that's going to look very different based from state to state, and even from region to region within states. If you're in a more rural area, it may be cheaper. If you're in a more metropolitan area, it's going to be more expensive. But I'd say you're looking at probably on average a couple $1,000s, minimum $1,000 up to several thousand to get some good independent contractor agreements and employment agreements in place. And then you can reuse them. Most firms will say, look, we'll put these templates together for you, and then you can use them with all your employees going forward, or all your independent contractor relationships going forward. So it's a long-term investment. And so I would say action item is basically, once you start having somebody else that's client facing or customer facing or vendor facing, then that person is probably getting exposed to relationships that you want to protect. And you want to protect those from the inception of that employment or independent contractor relationship. So that's the point at which you should probably go get an attorney and try to get some contracts in place.
Man, Aron, I love what you're saying. And had I not, again, for anyone watching, I'm a business growth consultant. And if any of you guys want advice about hiring and creating standard operating procedures, job descriptions, hiring processes, you guys can reach out to me on my website, emilyannpage.com, and schedule a free consult. And if you are in the state of Texas and you want to get a quote from Aron to be able to create those types of contracts, you can go to his website, which we have posted in the comments and chat. It's very simple. You can also connect to him on LinkedIn and send him a quick message, but he can help you with any of that. We just had a comment and a question from Nokomis Home Fragrance. And the question is, so you suggest having new employees sign non-disclosure agreements. So you answered that a little bit before. Can you just repeat it so it's super clear to them that what your opinion is?
If they're going to be dealing with sensitive information from the company, then yes, because that way, I think, just as a matter of course, it helps to impress upon them the importance of keeping information that is private to the company private and not telling the whole wide world about it. And so, if it's somebody that is not going to be dealing with any sensitive information, and for example, if you've got a large company, like I worked for Target or McDonald's when I was growing up, I don't need to sign an NDA because they're teaching me how to fry fries and deal with the cash register. But for most small businesses, your first few employees are going to deal with sensitive information because they're going to be dealing with your customers. They're going to be dealing with your vendors. They may see the books of the business if they're helping you with some bookkeeping. And so any of those would definitely warrant getting an NDA.
Yes, I agree. I love hearing what you have to say, Aron, because it's just really strong advice. And this is something else, and I'd love to hear what you think about it. But even, in some cases, it may never be in your best interest to litigate against a entry-level employee who maybe, let's say, took a picture of, maybe said something. You may not ever be in a situation where you want to litigate someone who's not a high-level employee. But it is just by having that contract in place allows you to have a conversation with them to be sure that they are clear what your expectations are. If you, for example, own a gym, you don't want the receptionist taking pictures of people and sharing it on her personal TikTok. These things, you may never litigate them if they did it because it may not be worth your time. But these contracts are supposed to be encouraging healthy relationships. So that it's a great opportunity just to have that conversation with them and clarify what the rules of employment would be working with you.
Yeah, it's like the phrase, as the saying goes, a pound of prevention is, no, an ounce of prevention is worth a pound of cure. I mean, that's the way I look at contracts. You're being proactive, and that ounce of prevention really does pay for itself in the long run, I think. And as you mentioned, large successful companies, they try to get those things in place early and then make sure they're part of the ways that they work internally, standard operating procedure.
So that's great. So I think that closes out that topic, right? Okay.
Yeah.
So next, we're going to talk about essential contracts for CPG brand owners and brand owners in general in the category of vendors and factories. We're covering 3 categories today. We just talked about employees and contractors, and now we're talking about vendors and factories. So Aron, what contracts should we as small business owners have in place to protect us in our relationships for vendors and factories?
So when you're dealing with people upstream, those vendors and factories that you're dealing with, you probably are going to need to have some sort of project agreement or service contracts in place so that it's clear what you're getting from them, how you're getting it from them. And you would also probably want to have some sort of intellectual property protections in there, for example, because I know some of the people listening, we're talking about producing things, manufacturing things here. So if you're manufacturing something, and I've got a patent on this widget, and this widget does whatever, lets people fly. You got a jetpack. So you're now producing jetpacks. Well, you probably have a patent on that, and if you don't have a patent, you should go get one. But let's say you have a patent on it. You should also, in your agreements with the vendors or factories that you're having produce the jetpacks, have them sign off on certain intellectual property protections so that they can't do things. Or and sometimes people can be creative with that. So that's why I think it's important to hire an attorney, because you can think of maybe 3 different things, 3 different ways to protect it. But an attorney who's dealt with that kind of thing regularly, or that deals with contracts regularly, might think of 6 or 7 different things, and their grid for the different ways that you're going to need protection is just going to be larger, just because that's their focus. That's what they've been trained to do. So for example, one thing I would want in there is some sort of provision that says, okay, you're not going to produce this, but also you're not going to take a sample and send it to other people. So, and in that way, cause somebody else to be able to replicate it or reverse engineer it. And, I don't know if you ever remember the movie Paycheck with Ben Affleck. It's an old movie. I think it was called Paycheck. But he would literally get contracted. It's a futuristic sci-fi movie to go reverse engineer different kinds of widgets for companies. And then they would wipe his memory. And yeah.
Aron, oh my gosh, I own a packaging company, and they would do that all the time. I would find out that people were they would even be posting our packaging designs on their manufacturers' Instagram, promoting that they had done something. And so even that confidentiality of saying, don't tell people that you are our contract manufacturer. Don't tell people that you are the exclusive manufacturer of, Aron and Emily's jetpacks, because even knowing that, if they want to copy your product, they'll just go right to that factory. And like Trader Joe's and a bunch of other companies that are large, like Target, they have contracts like that with you if you are the factory. And so it makes sense that if you are a brand owner, you're using a contract manufacturer, you should have that same type of thing in place. So what did you call that? You called that a service agreement. And so that would be different than a purchase order.
Yeah. So some sort of service agreement or master service agreement, because, for example, it's not uncommon for, if you're going to have an ongoing relationship with a company, to put some sort of base contract in place. So you might refer to that as a master service agreement, and that would have certain things that say, for the duration of this relationship, here's the rules of the game. And it would even refer to purchase orders. So you would have, under that master service agreement, then purchase orders that you can make, with different PO numbers or whatever you want, however you decide to sort that information. But you would have purchase orders and other potential ancillary contracts, work orders and such under that, and referred to under the master service agreement. And the master service agreement would be the thing that has the intellectual property protections, and it would also potentially have payment terms, as well as like a non-circumvention clause, so that ties back into what we talked about earlier. So let's say you have an employee who deals with all of your vendors and all the factories. And so this employee, worst case scenario, you have no contracts in place, and this employee starts to get a big head and thinks, I can do this myself. And so they go out and now they have relationships with all these factories. You could have some sort of non-circumvention agreement in place where these factories or vendors are providing this service to you, and they cannot provide the same service for the same widgets or that sort of thing to one of your employees who strikes out on their own. So that way they don't end up saying, hey, wink, wink, nudge, nudge, we'll work with just you if you jump out on your own.
Man, Aron, I just love that you're saying this. I'm going to turn this into an article. I'm going to send it to all of my clients who are in the product business, because I don't think most of them have product service contracts. And one thing I want to add to everyone who's listening, if you run a small business, there is this weird balance between when you're a startup and when you're actually successful. And so when you're just starting out, you don't have enough clout to really reinforce sometimes or convince a factory to, agree to outrageous requests. So your requests really need to be within scope of how much money you're planning to spend with them. Because if you give them a wild 200-page contract because you have a crazy attorney who's really all about good contracts and he's not very practical, you can actually hurt the relationship with your factory and scare them away.
True.
Unless you come with a big check and you tell them I'm going to do a lot of business with you and you're Apple. So when you're a small person, you need to have a reasonable contract. And if you really are already financially funded, then yes, you can have a more strategic one. But having said that about a contract that reflects the size of your company, if you're asking for the minimum order quantity, no one really wants to sign your crazy agreement. It's better be simple. You better ask your attorney to make one that reflects the size of your intended purchase order. But the other piece about it is that everything boils down to relationships, everything. Because even if you have a good contract in place and they sign it and then they violate it, you have to spend stupid money to go and chase that factory down and get, to fix it, right? This is why I respect Aron so much, because he is not the kind of person who's litigious happy. He's giving advice that's going to protect you from ever having to go to court. That's your best situation. You want these contracts to be kind of like an outline of saying, hey, this is what I'm expecting. Do you agree to this? And so you should be talking conversationally through a contract. Get your attorney to make the contract. Make sure you understand it before you send it to your contract manufacturer or your factory. And then most contract manufacturers don't want to even read your contract unless you're going to give them an order or they see a purchase order there. So write a quick summary of what it means, talk it through with them, go line by line, show them what it means and what you're trying to do, and say it in a friendly, you should be grateful that they're manufacturing your stuff, and say it in a way that is partnership building. And if you come across like a partner and you're creating this contract to increase the friendship level between that factory and you so that you guys can order tons of products in the future, that's the kind of language that you want to put in place. Just imagine if you're getting married to someone and you did a prenup and you give it to that person that you're so in love with and you're going to get married to and you want them to build a life with you, and you say it I think you're going to steal from me. That breaks down the relationship, the loving relationship. And instead, the way that you would want to approach it is, I expect to work with you forever. And I just want to be sure that we've talked through all the important elements, because we're going to make a lot of money together, or because we're going to build an amazing family together. So let's talk about the end at the very beginning, so we can just be not worried about anything and always feel secure in this relationship. So I think that element is an important piece. Do you have anything to add?
Oh, yeah. Yeah, and I want to touch on the phrase you said there near the end of feeling secure in the relationship. I think that's a proactive, positive way to say it, because comparing it to a marriage analogy, like you said, good boundaries are there to make sure both people feel safe being fully committed within the relationship. So in the same way, good boundaries in the form of a contract are designed to make both parties feel safe performing what they need to perform within the bounds of the relationship.
Yes. So for everyone watching, again, we're talking about vendors and factories, contracts that you should have in place if you own a small business. So what Aron just said is that you should have a services contract or a master service agreement. So that would be a contract that kind of describes, hey, factory, this is what I want a relationship to look like. It could have the terms of payment, Remedies, if anything goes wrong. Overages, you can talk about overages and underages, which means you might order 10,000 pieces, and whether or not you're willing to pay for product over, like you need to specify that. Non-circumvent, so don't poach my employees. Non-compete or confidentiality agreements, that they're not going to steal the clients that you're selling to. If you're a brand owner and you're selling to Target, you're using a contract manufacturer, you're the middle guy and you don't want to be removed from that relationship. So that's another element of non-circumvent. The intellectual property, NDA, confidentiality has to do with sending samples to other people or allowing someone else to have access to your IP. So these are contract elements that you need to have an attorney look at. And in addition to this, so whenever you're working with a factory, you have your services contract, and then you have to have a purchase order, which is the order that is specific to, hey, I'm ordering 10,000 units. So you have the contract, master service agreement, and then you have a purchase order. And the purchase order, you don't need to have an attorney look at. It just states your accountant should look at that. That's the number of units you're ordering.
Make sure it's accurate.
Make sure it's accurate. The terms could possibly be reviewed by an attorney, but that'd be a quick commentary. So Aron, do you want to give advice to anyone watching about, when do you hire an attorney to do this? What's the general scope of time or investment, or, what's your advice there?
So because of the complexity for this kind of contract, if you're getting an actual master service agreement or service, some sort of project agreement in place that's going to define the scope of the ongoing relationship, I would never bootstrap that agreement and get an attorney as soon as possible. Now, maybe, like you said, if you're a startup and you're just placing the minimum order the first time, then you may not have a choice. You may have to bootstrap it or see what agreements they have in place and take their agreement and then just try to negotiate it. And so that may be a way to kind of short circuit it a bit. But I think as soon as you're able to afford it, and generally it's going to be a point in time where it hurts a little bit still to hire an attorney. I mean, most people don't go, oh, I'm going to enjoy hiring an attorney. One thing maybe as a mentality that you may want to think about for attorneys, I think this is true for attorneys, CPAs, financial planners for small businesses, is kind of the 1% rule. As you grow, try to budget at least 1% of your revenue each year, at least, for professional advice, just going forward, strategic advice going forward. So that way, and that's not just like your tax return, that's required, but what kind of proactive things can you be doing as you're growing to protect yourself? And as you get larger, that number is going to go up. But if you have it in your head as a baseline of 1%, you're going to feel a lot more comfortable when you're $1 million company spending $10,000 on an attorney, because that's what's needed to help you grow in the most safe way.
Aron, I think that's so wise. And this is, again, why I enjoy talking to you, because this is very practical advice. So I've talked to some attorneys who just say, you should pay me $25,000 now. And I hadn't even started that idea. And you're like, I think this might be overkill. I don't even know if this is going to work. And then there's other times where I've met massive companies that don't want to have an attorney, and they have, 20 franchises and they're doing millions of dollars of business, and they don't feel that they would need it. And then something happens and they get sued and they don't even have a backup plan. So yeah. I love what you're describing is there's a timeline with your business when you're maybe ideating, especially if you're a small guy, like he just mentioned, you can talk to your factory. They probably have a service agreement in place. But the more successful you are, the more you need to have these things. And you don't want to wait until you're a wild success to do it. So you are responsible, small business owner, to learn and think about that proactively. You want to protect yourself, because it's just too expensive on the other end to lose a great idea or a great business from lack of having a good, simple contract. So, okay. So I think that closes out that conversation. So for everyone listening, this next thing we're going to talk about are contract essentials for small business owners that are related to clients and retailers. So that means anyone who's going to buy a product or service from you. What types of contracts, Aron, do we need to have in place to protect ourselves?
So looking downstream, going back to what we talked about at the beginning, you've got the internally focused ones with the employment agreements and independent contractor agreements. The upstream ones are what we just talked about. So now we're looking downstream. Who's buying our stuff? For that, you're going to be looking at really service agreements or some variation of those, some sort of purchase agreements, or so if they're just flat out just buying stuff and that's it, if it's just they're buying 100 of your widgets, you may not need that complex of a relationship with them. It's just they're going to need to pay you for that stuff. But if it's a little more complex, if there's some sort of consulting angle, or if you feel like there is a threat of them taking your intellectual property because maybe you're selling them something that is new and you designed it yourself, then you may want some sort of service agreement in place. With that service agreement, you can put the intellectual property protections we talked about, but also I would put in there some sort of payment terms as well as liability. So for example, if you're selling a product that could be dangerous, you want to make sure it's really clear who's got the liability for what and when, and probably the retailer. I mean, the default law, and I haven't brushed up on this today, but I believe the default is generally retailers aren't going to be held liable for something that's dangerous unless they messed with it. So for example, if you buy a lawnmower at Home Depot and it ends up killing somebody, you probably can't sue Home Depot unless Home Depot manufactured it. Now, I would want to double check that, but I believe that's the case. Basically, retailers are generally not going to want to take on any additional liability. But one thing that would be important, in maybe a service context, is disclaiming what you're not doing. So, for example, in my engagement letters, I put, I'm not providing tax advice. Because we may talk on things that deal with tax issues as a business attorney. So I'm not providing tax advice. I'm not providing business valuations because I deal in mergers and acquisitions. So you might want some things that disclaim what you are providing, saying, okay, here's what you're buying from me, but here's also what you're not buying from me. You cannot rely on me to provide X and Y and Z. And then in terms of what your remedies are within those agreements, you may want to put some things that give you some leverage in case they don't pay. So generally, the ways that you can try to go after people, there's a couple of ways. One, you hold their product if they're not paying you. So require payment in advance. Don't bend, don't break on that. Like, get them to pay you so that you send your stuff. If they're not paying you now, what motivation are they going to have to pay you later? And what leverage are you going to have to force them to pay later? If they're running out of money, and they don't have the money to pay you now, that's to me, that's a red flag. Don't send them the stuff. So hold their product. Another one is put a lien on stuff. So liens, the typical situation that any homeowner might run into is you have somebody come do contract work on your house, like your air conditioning, or they pour a new driveway or something. And then if you don't pay them, they can put a lien on your house. So that's, and a lien, to explain that as a legal concept, is basically something they go file in the public records. And then when your house sells in that situation, then the proceeds of the house, they get some of the proceeds automatically because of their lien. And so it's an impediment to selling the house generally, because before I sell the house, some buyer that comes along will say, we see there's a lien on your house. You need to pay that off first so that there's nobody else coming after us, and then we'll buy the house from you. So in the same way, you might be able to put a lien on products of various kinds. So there could be language in the contract, if you do have an ongoing relationship where you may send stuff before it gets paid for, that you have a lien on any inventory that has not been sold yet by them to secure payment by them. So basically, then you can come back and reclaim that product.
Right.
That would
This works with smaller businesses. So that'd be like when you're doing wholesale, you can confiscate. If you are an M&M manufacturer, but it's keto M&Ms, you can confiscate your inventory or just report the particular owner. It doesn't work with Target, this particular one. But so do you want to tell the next one, the next two?
You mean courses? Suing them and reporting them? So suing them, ultimately, you're going to look at what makes sense, from a dollars and cents perspective. If it's going to take tens and thousands of dollars to sue them, and it probably will, then you don't want to go after them if it's only a $5,000 amount of product. So you're just going to need to decide kind of where the threshold is for you there. In many states, there's some version of small claims court. So if you're a much smaller business and you're below that threshold, that's something to consider, because you can usually go to small claims court. At least in Texas, I recommend this to people regularly. Hey, go to small claims court without me. You don't need an attorney. It's kind of like if you ever watched the show Judge Judy. It's just you show up, have your documentation ready, have any witnesses with you that you might need to call, and just present the case the best you can. So that could be a way to go. And then, if they're not doing anything else, then use third-party reporting mechanisms. So if you can report them for not paying to credit agencies to the degree that may be applicable, leave reviews, basically create leverage out in the industry by, working against their goodwill. Don't say anything that's not true, but because then you open yourself up to a defamation claim. But make sure, you just use the leverage that you have, and if you think it's going to be useful at that point. And I'd say that's probably a last resort, because at that point you're going to be souring the relationship. But if
right, and you probably won't get paid. It's really more about warning other people to watch out at that point.
Yeah.
Yeah. So, this is such a juicy topic because I personally have run a business for such a long time, and I learned it the hard way. There was one company who called me on the phone, and he had already paid for a number of different products before. So, but it was always slow. It was always a big pain to chase him down and get paid for orders. And we used to have terms like 50% upfront, 50% deposit at the end. And so this particular person called one day and said, "Oh my God, I have the biggest order in the entire world. You have to air freight all of the samples because this person needs it by this date. It's Christmas coming. I need to have this last minute order." And I told him, "Okay, this is a lot of money. Do you realize air freight is 5 times as expensive as ocean freight?" So I was worried, and I went and got an estimate, and I sent it to him, and it was like $25,000 for the freight, plus something like $30,000 or $40,000 for the product. And I said, "Are you sure? Are you sure?" And he's like, "Yes, I'll do it." And I said, "Can you please pay?" At that time, I don't think I had terms to pay for freight up front. And so we initiated the contract. We had a signature saying, "I will pay it," signing off the estimate. We shipped it. We kept calling him to get some payment, and he hadn't done it yet. And at that point, it was like the holidays. One of the employees that was supposed to be watching it didn't hold the product. And even if they had, we would have been sideways holding it because we'd have to pay a holding fee. So we delivered it and never paid for the product. And to this day, I still see, the samples that we created in his stores. And after 2 years of time, so he made small payments, but I still ended up having to write off $40,000 or $30,000 of debt because I didn't have to pay it up front. And so now I never let anybody, no one can buy from me except for upfront, especially because it's all custom stuff. With a packaging company, I can't resell it to someone else.
Yeah.
If you're watching this and you're a brand owner, you have a little bit more recourse because you can make the candles and not deliver them or something to that effect. But these pieces of advice that Aron just gave is very, very valuable to anyone listening. If you don't, so just to repeat for anyone who's here, he said in your invoice, make sure that you have an invoice where you're going to invoice the client stating the terms. That's an accounting-based thing that's issued from your QuickBooks, but you also should initiate a service agreement. And this is especially applicable for anyone watching who sells wholesale. So if you own a brand and you are selling wholesale, you are selling to small businesses or to distributors, and you need to clarify for them the payment terms. So an example of a payment term applicable, your cash flow is the most important, powerful thing to keeping your business afloat. And so you can either request for payment upfront, 100%, because you're not really in the business of giving credit when you're small. So that's a great idea. As well as doing, if you are dealing with larger retailers will not pay upfront, but you can give them payment terms that reward them from earlier payment. So you could say, here's your price. We give 1% off for net 10. meaning if you pay within 10 days, we will give you 1% off, or you can give as much as 3% off, whatever it is that's going to really motivate you. And you need to not just put it in your invoice. You need to actually have a conversation with your buyer to clarify this, because this is about relationship. I've seen some retailers like Target. I know it wasn't Target. I don't know what retailer it is, and I probably shouldn't say it even if I did, but what they did is they saw this invoice that said, oh, we get 3% off for early payment. And they took the 3%, but didn't do the early payment. So, and I mean, there was such a big company, you couldn't get the money back. What are you going to do? Sit on the phone with their accounts payable department to argue over a few $1,000s? It never happened. So
I would.
Oh, you would. That's because Aaron's a good attorney right here. Aaron's a good attorney. So anyone who's watching, we're talking about client and retailer relationships and the contracts you need to have in place. And so right now, what we just said is that invoices need to exist, but so do service agreements. And in those service agreements, you should pre-talk about the terms of payment. So you got to pay me up front, or you have to pay within 30 days, or there's a fee. You need to talk about the process of collections, like how you're going to handle getting paid. Oh boy, overages and underages. So what will happen if they order 1,000 units, but your case pack includes 6 units. So you have to ship a little bit extra. You're going to charge them extra. So you might send them a revised invoice. Their purchase order might say 1,000 units. You'll send back an invoice for 1,006 units or whatever it is. Lead times for delivery. And you also want to talk about any other process for how you're getting them set up. So when it's wholesale, hey, it takes us 3 weeks before you can get your first purchase order. So that's what you would include in the service agreement per Aaron. And then you want to repeat some of those terms in your invoice, which is the accounting statement. And then the other thing that Aaron just talked about was getting paid when people, when they don't pay. You might want to even specify this in your services agreement with process collections, but you can hold their product. We recommend go ahead.
You can also have terms related to late charges, interest that gets charged after a certain point. So you can have an initial late charge if they don't pay within X amount of time, and then interest that starts accruing on outstanding amounts due, because you're not in the business of providing free credit. So if they're going to just take free money, then they need to be charged some interest on that. So that's another motivator potentially. Although usually businesses, if they get to that point where they're that far behind, they're either in trouble or they're just very risk tolerant is maybe a tactful way to say it. But it's not uncommon, I would say, in those situations, even when you have those terms where they eventually call 6 months later and say, okay, we'll pay it. And they don't end up paying the interest, and at that point, you're usually just happy to get the payment. I think the best way to make sure you get paid is to be proactive on the front end.
Yes, and even you can have different terms. If you're listening to this, you can have different terms when a client first starts to work with you. And so, because what I've found is that the type of client who's hard to get them to pay upfront or hard to get a hold of to pay afterwards, they will be like that for the entire business relationship.
Yes.
People who pay immediately, man, I love those people. First of all, they're like my favorite clients. You want to bless them, because if they're going to bless you by giving you money, you got to make sure they're your top priority client. But in terms of people who are your vendors or clients who are currently paying you well in the beginning of your relationship, you can expect that for the most part, they're going to stay pretty consistent. So you can have different terms that are related to someone in the beginning of your relationship, and after a certain amount of time of consistent payments, you can give them a little bit more credit. So
also, if they come back to you, that's a good point in time to apply leverage. So if they were late last time and they didn't pay the late charge and they didn't pay the interest, and they have something that's on fire, you can say, well, you still have this amount that's outstanding. So once you take care of that, I'd be happy to help you. I have a story about that happened for an attorney. They got stiffed thousands of dollars by this client, and this client couldn't find anybody in town to take on this lawsuit. Came back to this attorney, and the attorney said, okay, so you're going to need to pay the outstanding invoice, and you're going to need to pay this huge retainer. And you also need to put this other huge bonus in escrow, because if I win this case, I want a bonus just because I won. And unless you're willing to do all that, I'm not taking your case on. And so the guy had to pay it because no one else in town would take his case.
Right. And that's where Aaron, I love what you're saying here, because we're talking about a pound of, what do they say? It's a pound of
an ounce of prevention is worth a pound of cure.
So as a small business owner, it's risk mitigation. These contracts are about risk mitigation. And it's important for having a clear relationship with your client and vendor so that if anything goes wrong, you can protect yourself. But also, it's just great to talk to them about these things. Every client is different. You know, Trader Joe's pays on time. They always pay on time. They're a consistent, incredible company if you can get into your products in there for that reason. When it comes to payments, other companies consistently pay late. And so you need to get to know your accounts payable team, ask them questions when you're getting set up. And the more you know about them, the more you can mitigate your own risk. And the one other thing I want to throw out there for anyone watching, I do realize that when you're working with bigger companies like Target and Walmart, you don't get to have a service agreement. I mean, you can send one to your factory or to your retail buyer, or you can tell them, you can tell them what your terms are and send it to them and ask them to sign it. But their legal team is so much bigger than yours. And they already have a service agreement. They're going to tell you how they're going to do business. And you should call someone before you get into Walmart, call somebody who's sold to Walmart and ask them. Because oftentimes what you have to do is give them pricing before you see the contract, because they want to review, should I buy from this guy? And then they'll set you up as a vendor. What that means to you is that you don't even know they're going to charge you fees. So you sent them pricing, assuming that they're going to operate the way that other wholesale accounts work. And then you realize only after you sign the contract that, oh, they're going to charge you a fee if there's spoilage, or you have to pay a slotting fee, which is $1,500. Well, there goes your margin on your first order. So you should call someone to ask what the service agreements are like and the payment terms are like for any big companies, big companies, because they can flatline you as a small emerging brand if you don't understand those things. So go call someone. And the second thing is they will give you a service agreement that is going to be way outside your scope. So have an attorney read it.
Yeah.
Have your accountant read it. Have multiple eyes on that thing. I
can't tell you how many people have come to me or my office, and they've already signed the large agreement, the 50-page, the 75-page document. They started a franchise. They got into business with a larger company, something, and they didn't get legal help on the front end. And now the relationship's gone south. Now their business is dying. Now the other side is applying pressure to them. And basically, at that point, I'm like, I'm sorry, I can't help you that much to negotiate this. All I can do is point out to you what your rights and duties are under here and tell you what you're supposed to be doing. But if there's not an out, sometimes there isn't, then they're stuck in that relationship. Like, in the case of franchise owners, that happens sometimes. They are then stuck owning a franchise and they literally can't get out of it. And it's a terrible situation.
That's really, really poignant. And I think the important thing for anyone watching is there is so much enthusiasm when you first get an offer from Costco, Walmart, Target, the bigger the retailer. You're really excited. You're so excited. You want to do anything to get in there. And in your mind, you're like, this is what I've been dreaming about. Most retailers or brand owners that I talk to, when they call me for consulting advice, how do I grow my business? They tell me, I'm going to one day be in Target. That's my goal. So they're fixated on being in Target, but they don't have the addendum to the sentence, which is, and be profitable. Get on the store shelf and stay on the store shelf. Get on the store shelf and continue to sell. And so if you don't review your contract before you sign it, the pricing that you give them or getting into Target too early in the evolution of your company could crush you because you don't have the processes in place. You're not ready to fulfill your service agreement. And imagine this world. Okay, we're talking about the worst case scenario where a company doesn't pay you. It's unlikely that Walmart won't pay you. They might just pay you on their own time. But a worse situation is you sign a service agreement that requires a purchase delivery, for example, on a purchase order within 2 weeks. This is a typical thing that happens in a service agreement. The retail buyer is used to working with large companies. You're a small company. You've never made large enough orders to fulfill to Walmart. So they order one full truckload, and for some reason, there's a supply chain issue. You can't get the glass for your candles. And so you owe this purchase order within 2 weeks. All of your team is hustling. You can't get the glass. You're working 3 shifts a day, and you miss the delivery date. You know what your buyer is experiencing? They have shelves that were dedicated to your product, and there's nothing on them. And what does their boss say to that retail buyer? You idiot. You bought some product. You took a risk on a vendor who doesn't have a good system in place to be able to fulfill your purchase order. You idiot. So that's the boss talking to the retail buyer. So how do you think they feel about you when they're up for review and their bonus and they didn't make their sales quota for the month?
Not happy.
Oh, so unhappy. So you, business and brand owner who's watching this right now, this is another reason why you need to not only have an attorney read this contract, but an accountant or a business growth consultant, because you just need multiple tiers of advice to protect you. Yes, you want to get into Target. Yes, you want to get into Costco, but not before it's the right time, not before you can do it in a safe, productive, happy way where you can fulfill the requirements of a service agreement with them. Don't accept and sign a service agreement until you understand the consequences of it, because if you mess this one time up, you will never get in there again. They will not forget that you screwed them. Yeah. So
to steal to analogize to a different situation, one of my favorite pastors has a phrase related to promotion. And he says premature promotion, before you've laid the foundation with your character, will destroy you. So in the same way with a business, overly aggressive growth or expansion before you've laid that foundation will destroy your business.
I love that you took it from a super practical thing to even like a higher level macro piece. And this is again why I appreciate talking to you, Aron, because you have business in mind, but you also have like that internal compass. And for anyone else watching, I would agree with that. Life, we can get so fixated on the outcome of growing your business, becoming a multimillionaire. Everyone wants to work remotely and have passive income. This is our lingo of our culture right now for any business owner. But at the same time, dude, it's about the journey. It's about who you're going to become in the process, who your business is going to become in the process. So if you are watching this and you own a small business, what we are basically saying is that contracts need to exist. And the reason why you need to implement contracts is because you need to have healthy relationships. You want to have healthy relationships with your employees and contractors. You want to have healthy relationships with your factories and vendors, and you want to have healthy relationships with clients and retailers. We want to have integrity internally, and we want them to have integrity. And sometimes 2 people can have a ton of integrity, but not understand the terms of what the other person is expecting. So an effective and good legal contract is going to itemize those things, clarify what does it look like from both sides, what are the expectations. And so you need to have contracts in place. To close out this particular topic of clients and retailers, Aron, can you just help again answer that question? When is it okay to make a service agreement or accept the one that they're giving to us, or maybe buy one on LegalZoom? And when should you have an attorney craft a brand new one, or maybe even read it? And what's the terms of that? Like how hard or expensive would that be? Should we have someone on retainer? Explain the terms of having an attorney help us with this.
Yeah. So I'd say on this piece, also not doing it on LegalZoom, because it's just not the kind of contract where I would trust. And I know we've knocked on LegalZoom a bit, but LegalZoom, I think Rocket Lawyer, there's a couple others. If you scroll down and look at their terms and conditions, just to give you a couple of things about them, they explicitly disclaim any attorney-client relationship. So they're not actually providing legal advice. They're basically TurboTax for lawyers. It's self-help, it's do-it-yourself, which I understand is the attraction, but you get what you pay for. And they explicitly disclaim, for example, that the things that they're giving you will actually do what you want them to do. So they're literally disclaiming the very product they're providing in their disclaimers. So they're like, here's these contracts. We hope they do what you want them to do, but we are not guaranteeing that in any way, shape, or form. So with service agreements, I think getting an attorney to draft it for you or review it for you is important. And in terms of when to have a brand new one versus when to just review what they've got, I think you just have to look at where you're at in your company's growth stage. If you're just starting out, you probably don't have a lot of leverage. You're going to have to take what they give you. If you've gotten to a size where you feel like it would be useful and you're negotiating this on a somewhat regular basis, at that point, it might be useful to have an attorney draft one for you as kind of your company's template. And so I think as you grow, you get that in place. It's definitely cheaper to take theirs and negotiate it than to draft one from scratch. In terms of cost, you're probably going to be looking at anywhere from $1,000 to several $1,000s, and depending on the size and complexity of it, it could be $5,000 or $10,000. And so it just depends on what we're looking at and the scope of that.
Oops. Well, and to add to that, I think what I was going to say is that I think when you have when you're getting into target, that is when you have an attorney look at it 100%. And you also should have an accountant look at it, because you need to understand what these fees could possibly mean for you. That's really important. So in the case of a very large retailer, they will have a service agreement, have an attorney look at it. That shouldn't take longer than, they can tell you based on how long it is, how long it would take. And then when it comes to drafting your own contract, if you are doing wholesale, of course, you need to have a template. You should have something, in place. And so you can even do, this is what I've done with my attorneys moving forward, especially if you don't have an attorney yet and you don't know the personality of your attorney. You don't know, are they going to give you a 100-page thing? That what I've typically done is I've written out kind of like a memo of understanding and saying, like, this is what I think I need to have included in the contract. Like I started a business. I started a ready-to-drink beverage company. And with that person, he was so much more successful and rich than me. I wanted to be sure that before I paid an attorney to make the contract, that I knew between me and the partner what we were going to agree to. And then I wanted to send that to the attorney so he didn't add crazy things into it, or so that he could advise me on what else should be added. So write out a memo of understanding for yourself. This is what I'd like to have included in my service agreement contract with my wholesale clients. And then send it to your attorney, and that will make your process even more affordable. But also, you'll both be on the same page, so you don't hire the wrong attorney. You'll hear as he or she is advising you exactly where their heart and mind is at, and that will be the sign. Oh, this is the guy I want to work with. He's giving me great advice. Then he can give you an accurate quote because he'll understand the scope, and that's, I think, the best way to go about it. Would you agree, Aron?
Yeah, I think that's definitely a great way to go about it, because you want to make sure your attorney is giving you something that's going to be useful for you. No attorney wants to crank out a huge contract only to be told this is useless. So I think making sure you're on the same page. Now, sometimes you may think this needs to just be 1 or 2 pages, and that's just not possible. So understanding what's realistic, because there are certain terms that need to be in there. But yeah, I think trying to make sure you're on the same page with the other person, and then giving those kind of cliff notes, if you will, to your attorney is important.
Okay, so that's wrapped it up. If anyone is here, you're welcome to ask questions and put them in the comments. But as we're closing things up, at least the educational part, I just want to say thank you, Aron, so much for being here. If anyone is watching,
you're welcome,
and you want to hire Aron to be your attorney, he is licensed to practice in the state of Texas. So he can only advise you and become your attorney if you are in the state of Texas. Aron, would you mind please sharing with us where people can find you?
Yeah, so my firm is the Law Office of Aron Phillips, and that's just with 1 A, so just Aron, and then Phillips with 2 L's. So you can find me on Facebook, you can find me on LinkedIn, as well as my website is aphillipslawoffice.com. So that's aphillipslawoffice.com, and Phillips is with 2 L's. But yeah, I look forward to connecting.
Yeah, and his LinkedIn is there too if you just want to add him as a friend. He's a great guy. So if there is any questions, please go ahead and add it into the comments section. Again, just to summarize what we talked about today, it was contracts for small business owners. And we're especially focusing on product businesses today. And that applies to employees and contractors, vendors and factories, clients and retailers. We already had a couple of questions and I don't see any more being posted here. So I think what we'll do is close up for the day since we said we'd do this for an hour. Any other questions, you guys, feel free to add them in the comments after this video has been closed, because we will get back to them a little bit later, or reach out to Aron specifically. And thanks so much for joining us today. Thanks again, Aron.
Yeah, you're welcome. It was a pleasure. Thank you, Emily.
Okay, bye. Bye, everyone.